Thank you.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. The panel today consists of Justice Henry, Justice Singh, and myself, Gabrielle Wolohojian. We are conducting argument in this format because of the ongoing pandemic. Although we're conducting court in this fashion, all the ordinary rules of oral argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'll call the case of City of Malden versus Robert ZERASCHI, and I hope I pronounced that name correctly, 2019 P 1704. Attorney McNaught?
Yes, Your Honor.
We're ready whenever you are.
Thank you, Your Honor. Justices of the panel and the appeals court, my name is John McNaught, Jr. I'm an assistant city solicitor for the City of Malden, and I represent the city in this matter. Good morning, justices, and may it please the court. There is no case, statute, or legal principle that allows a private property owner in Malden, Massachusetts, such as the appellee, Mr. ZERASCHI, to operate an open-air parking lot for a fee without obtaining a license beforehand. In fact, state and local law require a private property owner in Malden to obtain a license to run such a business. This legal reality frames the city's presentation today, underscores the errors in the Superior Court's rulings on summary judgment and civil contempt, and illustrates the shortcomings of the appellee's position. The legal reality also supports the appellate relief that the City of Malden seeks, namely, 1, an order to the Superior Court to award a permanent injunction and declaration that the city sought in the underlying litigation, or, in the alternative, a rehearing on the city's motion for summary judgment. And number 2,
counsel,
yes.
There seems to be a dispute between the parties concerning whether you have to show it would be in the public interest, or at least not against the public interest, for an injunction. Can you explain whether, why your opponent is incorrect, and whether there does need to be consideration of the public interest?
Yes, Your Honor, I would be pleased to do so, and I too am looking away for a moment to get my paperwork. But with regard to the public interest, in certain circumstances, the cities and towns, in order to obtain an injunction, have a two-pronged test. And that two-pronged test involves a circumstance where the city has to establish not just a likelihood of success, but that there's a public interest. In this particular case, Mr. ZERASCHI, both before the decision of the lower court and after the summary judgment in favor of the city, went ahead and continued to use his open-air parking lot. Clearly, it is in the public interest for the court to have provided the city with that injunction, and in addition to provided the city with the finding of civil contempt post-judgment, because he continued to operate it in the same way. So
I'm trying to break that down then, because if the injunction issues 100 parking places go away, so either it makes it harder for people to take public transportation or increases pollution. I'm trying to understand where the benefit to the public is.
Where the benefit is? Well, certainly there's a benefit to the public if it has the ability of the city to oversee these licensed lots, these open air lots. For more than any complicated reason, the very simple reasons are that there are city police, fire, people at City Hall, all of whom have to in some way or another interact with an open air parking lot should anything occur. Let's assume for a moment somebody gets off the T station right where this particular lot is located. They would expect at the very least, some protection regarding their safety. And that would involve not Mr. ZERASCHI, but would involve the city having to portray the police to come and take care of that particular circumstance. If there's a fire in one of those vehicles at the parking lot, the city and fire department would have to come and make sure that that fire was put out.
So
Those,
you're saying that getting the injunction doesn't necessarily mean that 100 parking spots go away. It just means that that they could possibly keep it as long as they do things within the regulations and pay the associated fees.
yes, they're not forbidden to use this as a parking lot. They only have to, they can choose not to use it as a parking lot, the owner. But if they choose to use it as an open air parking lot, then this fee is then given to the city in order for the city to provide that type of protection. So it's really not mandatory so much as if they want to perform the service of an open air parking lot, then you pay the fee.
Has the city issued a cease and desist?
Well, the truth of the matter is the city has given notice by way of letters. The letters are attached to the appendix. And the city has given letters and almost on a daily basis
But were those
has
cease and
cited,
desist
I'm sorry,
letters?
go ahead, Your Honor.
Were those cease and desist letters?
Well, they're
Those
the
were-
equivalent of a cease and desist order.
No, I'm not asking that. I'm asking whether they ordered the operator of the parking lot to cease and desist operations.
The answer has to be yes if you accept the letter indicating that he's supposed to come to the city hall because he's been operating an illegal parking lot.
All right, what I saw in those letters, so perhaps you can give me a page reference to one that uses the word cease and desist. What I saw in those letters were a requirement that he come and pay the outstanding fine amount.
The original letter indicated that he should come because he's operating a lot and has not yet sought a license. If you'll give me a moment, Your Honor, to look through the index in the appendix.
Well, we can look, and I don't want to take up your time unnecessarily for that. I have another question for you.
Yes, Your Honor.
Are you familiar with the line of cases that says courts will not issue injunctions to comply with the law? In other words, we don't issue injunctions that say you must, for example, not violate chapter 151B. And how does this injunction that MALDEN is seeking differ from an injunction of that sort?
Your Honor, I'm familiar with the Town of Framingham versus Framingham Police Officers Association, Commonwealth Avenue versus Crink, all of which we've cited and which indicate that an injunction should have been issued when sought by the public authority to promote both the public interest and because the municipality.
Those cases stood for the proposition that the injunction, they were not seeking an injunction just to force compliance with an existing regulation, were they?
Well, the answer is yes and no. Certainly under the Town of Framingham, the municipality sought the injunction because the particular duties of the police department concerns public safety, was not subject to collective bargaining, and therefore wanted the enforcement of its injunction to be issued. In the Crink case, the test for injunctive relief was involving the Attorney General, who was had a general statutory mandate in addition to any specific statutory mandate to protect the public interest and a common law duty to do so. So when a government acts to enforce a statute or make effective a declared policy, the standard of public interest and not requirements of private litigation measure the propriety for injunctive relief. So I'm aware of those circumstances.
All right, I'm looking at page 135 in the appendix, which I believe is the letter that you were referring to earlier. Is this what the city is relying on as a cease and desist letter?
Your Honor, it was not the first letter. But yes, we would rely on that as well.
Okay, so let's assume that's not a cease and desist letter.
Okay.
And let's assume that the city has not issued a cease and desist letter. Does the city have the ability to send a cease and desist letter? Is there a regulation or something that gives it an enforcement mechanism of that sort in case of violation of the regulation of paying the fee?
Well, General Laws, Chapter 148, Section 56, passed in 1930 and adopted by the City of Malden in 1934, provides that mechanism, as does the ordinance adopted by the City of Malden back in the 70s, which was the Section 6.47. And that provides, as indicated on page 129 of the appendix, that anyone using an open air lot must comply with Section 6.47. And that provides for regulation and fines, penalties for disobedience.
So I just want to be clear, because I didn't see this in the record. There's no letter from Malden to Mr. ZERASCHI saying, you must stop operating a parking lot as of such and such a date.
Those words may not have been used, Your Honor.
Okay, so in those circumstances, why is the city entitled to an injunction from the court?
Because the city provided to Mr. ZERASCHI notice that he needed to obtain such a license, pay the application fee, comply with the terms and conditions of the ordinance and the statute in order to operate his open air lot. He went ahead and did so. I'm sorry.
And the city has a mechanism.
Yes, Your Honor.
To help itself, which it apparently has not taken.
I'm confused, and I'll tell you why I'm confused, Your Honor. I believe that what the city had done was give not only notice of what the requirement is for Mr. ZERASCHI, he then ignored it. After ignoring it, he continued to receive, almost on a daily basis, these citations indicating to him that he was in violation of the ordinance. Certainly, he had known that this ordinance and law was applicable, that he had to obey it by paying the appropriate amount, and by failing to do so, he was receiving fines. Ultimately, because he completely ignored everything, the city brought a petition saying, you know, you have failed to comply, and we ask the court now to help us out with this scofflaw. And then we receive a judgment, and he still continues to disobey, even though it's been found by the court that he violated the ordinance and statute. I think, Your Honor, that the magic words cease and desist were quite unnecessary in this particular case, because all the other writings that were sent to him over periods of time certainly indicated to him that he was doing something wrong.
But on the contempt issue, you agree that there was no order in place directing any particular conduct, or precisely because you didn't get the injunction. There was no order that was actually being
I disagree.
violated.
I disagree, and I want to point out why. In this particular case, the lower court did issue a finding on summary judgment that in fact, Mr. ZERASCHI was operating an illegal lot. And in doing so, he continued to operate it after that particular finding was made by the court. And that injunction, once made, becomes an order, and that he violated that order as well. So therefore, the contempt in this particular case, and I'm looking for my cases regarding contempt, indicate that he should, please forgive me for my delay, but that I know that I've cited these cases. You have to forgive me. I know that I've cited cases that indicate the following. Once an order of the court, a finding is made, it becomes an order of the court. And when someone has been given that particular finding and they continue to operate an open air lot without having gone to the city to get the appropriate license, then they're in contempt. So,
But Russell, I think the concern for us, or what we're trying to understand, is it seems like you asked the judge below to issue an injunction telling him to stop operating the lot, and that the judge declined to do that, and then you move for contempt. Are we correct that you asked for that and the judge declined to give it?
yes.
Not, okay.
Yes, in both instances. One, the contempt, however, had to do with at least operating the lot after the order had been handed down by the Superior Court with regard to a summary judgment finding.
But you agree that the judge did not order them to the judge did not expressly say stop operating the lot.
That's right. The judge didn't, and that's why we feel a mistake was made, that an injunction should have issued in this particular case.
Can
Okay.
you address, if you will, the argument about this is an unconstitutional tax?
Yes, Your Honor. We point out several cases. Route 1 Liquors versus Secretary of Administration and Finance, cited in our brief, 439 Mass 111. And in particular, in that route, that also had to do with a license to operate an open air lot. And in this particular case, it is well established the obligation to pay an excise tax is based upon a voluntary act of the person taxed enjoying the privilege. But a person cannot operate an open air lot without a license from the appropriate municipality under the statutes that I indicated earlier, and that there would be penalties if they did so. That is cited at page 116 and 117 of Route 1 Liquors. Emerson College versus the City of Boston, a 1984 case, indicates that proprietary fees do not implicate the taxation power if based on a fair recompense for the public monies expended for initial construction and adequate of maintenance of facilities used. Similarly, regulatory fees are not taxes if commensurate with governmental expenditures occasioned by regulated party. The general rule as to regulatory fees is that, quote, the costs to the municipality which may be considered are not simply those which arise directly in the enforcement of the regulatory provisions themselves. The license fee may be properly fixed with a view to reimbursing the city, town, and county for all taxes and all expenses imposed upon it by the business sought to be regulated.
Okay,
I believe that
we're going to have to leave it there. Your time has expired. Let me just see if there are any other questions.
I just want to make sure you agree that your opponent did assert his claim about the tax being unlawful as an affirmative defense.
he may have. Please forgive me for, I'm a last minute insert. So I pray that because of my inability to answer you specifically with regard to that answer, I do know that there had been a ruling with regard to that in the summary judgment memorandum of decision, and that the appropriate information and evidence had not been provided. Did I answer your question, Your Honor?
Yeah, that's fine.
Thank you.
Thank you very much, Attorney McNaught.
Thank you.
Attorney McAvoy, if I pronounce it
That's correct. Thank you, Your Honor. Patrick McAvoy for Robert L. ZERASCHI. And may it please the court, I would like to start by addressing just the overarching idea that the city of Malden, and I think we addressed this in our brief, wasn't really entitled to summary judgment to begin with, because they never really got to the point where they addressed whether or not this could be an unlawful tax. And that was certainly a genuine issue and something that needed to be addressed by someone seeking summary judgment.
Do you think that depends on a development of a factual record?
I would think, Your Honor, once the defense is asserted as an affirmative defense, and someone seeking summary judgment has to address it in some fashion. I mean, we feel there is some dispute about how much evidence was given and what evidence should be counted in the lower court. We think if one goes through the appendix and goes through our brief, you'll find that we submitted a lot of evidence relative to the idea that this was an unlawful tax. And
But the city argues that the way you did that via the attorney affidavit, that cannot constitute admissible evidence for purposes of defeating summary judgment. What do you say to that?
It's my understanding, I think we cite a case in the brief that says that an attorney's affidavit is valid and can be submitted on uncontested facts. And these were uncontested facts. What we did in the lower court was we took the discovery, we had a pile of discovery that the city provided us, parsed through it, took out the relevant facts and submitted those to the court in the form of an affidavit.
Usually, and I would like to know, I confess I haven't read that case, but usually the uncontested facts are authenticity and foundation. They're not the uncontested facts contained in materials the attorney is seeking to put before the court.
Well, Your Honor, if that was brought up at the lower court, we certainly could have handed over the evidence that was given to us, but it would have just been a pile of documents.
The question is twofold, it seems to me. One is, or maybe even more than twofold. The first is, are you correct that you timely asserted the affirmative defense in response to the amended pleading? The lower court thought you had not. The second question is, if you did, who has the burden on an affirmative defense? Ordinarily, it's the person asserting the affirmative defense. I don't think that changes just because the issue was raised in a motion for summary judgment. And then the third is whether, if it is properly placed before the court in the summary judgment, whether the underlying facts were undisputed to a degree that that the question of whether this particular fine constituted an unconstitutional tax could be determined as a matter of law. All of those things seem to me to be at play here. And you're asking us to determine them as a matter of law in the first instance on the appellate level.
Okay, Your Honor. Well, actually, I don't think there's any dispute that we did assert this as an affirmative defense in our answer to the amended petition. So even if you do throw out our counterclaim as the lower court did, it's clearly there and it's supported by the rule that it should be treated as a counterclaim. There is citation in our brief to cases that essentially say, even if the burden of proof is on, say, the defendant in the action, the person seeking summary judgment has to address the issue. They can't just completely ignore it as that was Malden's position, is essentially, well, it's their burden, so in summary judgment, we don't have to go and even deal with that at all. They haven't put in any evidence whatsoever with respect to this issue. So as a summary judgment matter, I don't see how you can do that.
Well, because if the evidence that you put in was inadmissible, then maybe they don't need to put anything more in.
Well, it can't all be inadmissible. If you threw out my affidavit, which I don't think you do, but even if you did that, there are records from the city of Malden in the appendix showing that they had a zoning ordinance in place when they adopted this. There are the schedules of fees from the city of Malden that show what they normally charge for things and how that's totally disproportionate for the amount that they're charging for this. There's Mr. ZERASCHI's affidavit, which is surely good evidence about what went on at the property, what he pays for other services in the city, and how that's totally disproportionate to what he's paying or what the city wants him to pay for these parking spaces, which was $100 per space for a yearly inspection, which
Is this the only private parking lot operated in the city of Malden?
no, there are at least five to 10 others. There have been very few enforcement actions, which is something we set forth. The enforcement there's no real enforcement of the regulations. The real focus seems to be, as far as we can tell, the collection of the check. I mean, some of these applications that they supply to us don't have plans sometimes. They don't have the stamp from the fire department. They don't have the stamp from the building department. It's just, and the only thing that the city of Malden is focused on through this entire litigation is the checks. The payment of that fee is the central issue. The idea that there need to be attendance, that there need to be lighting, that there need to be striping in any of these lots around the city, is going completely unenforced, which I think lends heavily to the idea that this is just a fee generating and a revenue raising thing for the city. I don't see how you could see it any other way. I know my client sees it that way very strongly, and he's a businessman. He understands the city. He understands fees, and if they had imposed a reasonable fee for this regulation, if they needed to do so, that wouldn't have struck my client strangely at all. But the $100 space fee is incredible, especially when you're paying $11,000 in real estate tax every year.
It doesn't seem to me necessarily relevant what the fees are for other services. That doesn't, is there, what is your best case for the proposition that one would determine the constitutionality of a particular fee by looking to reference, by referring to other fees that are charged for different services by the same governmental entity?
I don't think you would do it as a single thing. I don't think you could say, well, this fee is disproportionate to other fees, therefore it's not legal.
But do you have any?
I don't think this works, but it's a brick in the wall of evidence, Your Honor, that you're building up. It's part, you have all of these things that come together, and you look at it, you say that can't be right. It's not, and this is the evidence we get.
I understand your point. I'm asking you for a case.
A case that suggests that I don't know that there's a case that suggests that disproportionate amount of the fee is part of the evidence. I think that's just something, it's just logical. But I don't know the case where.
So, but if the city were to, like, let's say you point out that it costs a lot less money to inspect an apartment that someone lives in, right? And I understand your point, but perhaps the city is charging a discount or even taking a loss on those inspections because the loss of life or the risk to someone living in the apartment is greater, and they want to make sure people sign up for it, right? Whereas if their enforcement of fees takes 100 space parking place out of the market, well, so be it.
I think that's certainly an argument that the city could have made at the summary judgment level and could have made at this court, but it's an argument. At some point, I think the fee become the fact that it's totally disproportionate is problematic. If it was double the fee for the inspection of the houses, that might be a discount. But you're talking about comparing a parking space at $100 to a three unit building for $100, and I think that. And I don't think that stands alone. I don't think you could come to court with just that, but I think it's evidence. And also, I think that as a citizen going to the city and doing discovery with the city and getting the response that we got, that's what we have to rely on, is the circumstantial evidence that's around, and also the evidence that we base, the lack of enforcement, things like that, and then add them all up, because there's no legislative record in the city of Malden regarding this particular law. There's no discussions. There's no legislative history. I can't. What you have, it's really all we get to look at, and where the city's not going to come forth and say this is how it works, this is what it pays for, this is why we did it, then that becomes even more of a problem for us because we don't have a way to argue with them.
So because it's summary judgment, let's just be clear. You are not disputing that your client operated an unlicensed open air parking lot, right?
Correct.
And does the record include an explanation, or did your discovery include a request for an explanation as to how Malden set what you think, with some force, is a ridiculously high an amount that really is a tax? Did they explain how they got to that amount and why it's different from what they're charging for other things?
We've asked several times and it's never been explained to us.
But did you move to compel on that then?
I don't think we did, no.
Did
What we would have anticipated is,
did you
and I
propound
think
an interrogatory?
we did send interrogatory. We sent a long, well, not long, but a good size request for production documents.
But was there an interrogatory to the city asking for an explanation
There was not.
regarding?
What we would have asked for is documentation regarding. We didn't know. Yeah.
And in your view, are the letters that the city has sent the equivalent of cease and desist
No.
letter? All right, if the city were to send a cease and desist letter at this point, I take it your client would understand that he needs to cease and desist?
I would likely have to research that, Your Honor, because I don't know the parameters. I don't know what the City of Malden's rules and regulations regarding that are, and I don't know state law regarding the cease and desist letters for this particular aspect of things.
Counsel, do you agree that it's in the public interest to have the laws and regulations enforced?
If they were, I think our basic argument with that is that they're not particularly enforced. It's not really an enforcement issue with the city. It's a filing and a check issue with the city. They don't, in their history, there's never been enforcement regarding lighting. There's never been enforcement regarding striping. There's never been enforcement regarding paving of these parking lots. So I don't.
So you're basically saying they just want their cash, which I think your client might say was a shakedown.
I think that's kind of, I don't want to put it as negatively, but yes, I think this is about the city getting its money from these parking lots. Some of them pay 1 year and then they don't pay the other. My client was operating this parking lot for 7 or so years before anyone talked to him. And in this litigation, they have not pursued one item of compliance other than the filing of the fee, the application and the payment of the money.
It seems to me an odd argument to argue that you want them to do more than they've done.
I'm not arguing that I want them to do more. I'm saying that their complete lack of enforcement and their complete lack of interest in any other aspect of this points to this being a revenue raising project.
Well, all fees to some degree raise revenue. That can't be the test alone, correct?
Correct. I'm certainly not saying that's the one thing. I think there are a lot of things that come together that point in the direction. And I really think that a remand to the Superior Court might be warranted here if more needs to be presented in order for this to be fully considered. To throw us out, we did provide some evidence. I don't think there's any doubt that we provided evidence. We asked for summary judgment. The other side did not provide any evidence, and we've been dismissed. So procedurally, I don't see how that could be, how that works. I think that they were wrong to throw out the counterclaim and then dismiss us that way, because we clearly asserted our rights in the answer. It should have been treated as a counterclaim. It should have, the evidence should have been considered because there certainly was evidence, and there was no evidence from the other side. Maybe we weren't entitled to summary judgment, but we were certainly entitled to survive dismissal, especially when the other side hadn't offered anything with regards to the law, how it's adopted, and why it's justified.
I think we understand your argument. Let me see if there are any other questions for you. No, I don't think so. Thank you both. This is an extremely interesting case, and we have been helped by both of your arguments. It's been very helpful to us, so we thank you. And with that, the case is submitted.